Hi, this is J. Sai Deepak. I am a senior associate at Sai Krishna and Associates. I have been litigating with Sai Krishna and Associates for the last 5 years before the Delhi High Court, the Intellectual Property Board, and the Indian Patent Office. The module that I will be speaking on at this point is patentability of computer programs, its position under Indian law. Article 27 of the TRIPS is the first provision that needs to be looked into to understand the obligations and flexibilities that are available to member states in terms of the subject matter that may be allowed or that may subject matter for which patents must be granted, and subject matter that may be excluded from the scope of patentability. Specifically, the provision that needs to be looked into would be articles 27.2 and 27.3. 27.2 and 27.3 permit member states to exclude subject matter such as diagnostic methods, methods of treatment, inventions relating to the treatment of plants, animals, so on and so forth. Specifically, Article 27.2 permits member states to exclude subject matter from the scope of patentability on grounds of morality and public order. It is an exercise of this flexibility that is provided under Article 27.2 of TRIPS that India chose to exclude computer programs and several other subject matter from the scope of patentability, and this was introduced through the 2002 amendment to the Indian Patents Act of 1970. The provision that we will be discussing at this point is Section 3K of the Indian Patents Act, which excludes from the scope of patentability computer programs, algorithms, and business methods. It is clear from the language of the provision, which is Section 3K, that the provision strikes a distinction between computer programs per se and algorithms. Based on a layman's understanding and also an understanding of a practitioner of computer programs or that particular technology, it could be said that an algorithm is merely a sequence of steps to perform a particular process or to achieve a particular result. In stark contrast, when there is a reference to computer programs per se refer to the execution or the adoption of that particular algorithm in a computer understandable language or in such as Java, so on and so forth. The question that needs to be asked is, as opposed to specifying computer programs, is there a reason that the provision restricts itself to computer programs per se? The answer to this question must be found or is to be found in the Patents Amendment Bill of 1999, where the reference was restricted to computer programs, but it was narrowed down further in the final version of the bill to computer programs per se. What was the intent behind such restriction? What was the what is the import or interpretation of computer programs per se? Unfortunately, we do not have case laws identifying or explaining this particular aspect of the provision. The only two decisions that are available under the Indian law at this point is the decision of the Controller of Patents in Yahoo versus Rediff.com, which was then appealed against by Yahoo before the Intellectual Property Appellate Board, but to no avail. The Controller of Patents in this particular case dismissed the patent application of Yahoo in a pre-grant opposition that was filed by Rediff.com. And one of the grounds for dismissal of the patent application was that it attracted the prescription of Section 3K. It must be borne in mind that the dismissal of this particular patent application was on the basis of the fact that, according to the Controller of Patents, the subject matter that was claimed was more of a business method, and therefore there was not much of a discussion on what is a computer program per se within the meaning of Section 3K. Similarly, there was no discussion on computer programs before the Intellectual Property Appellate Board. The reason it is necessary to understand or read these two decisions in the context of patentability of computer programs is this. On one hand, the Controller of Patents chooses to look at subject matter eligibility under Section 3 of the Patents Act before proceeding to issues such as novelty, non-obviousness, and industrial application. On the other hand, the Intellectual Property Appellate Board goes on to discuss grounds of novelty and obviousness before discussing the issue of Section 3K. Now, this shows two distinct approaches and two diametrically different approaches for one good reason. If Section 3 is meant to filter the subject matter that may be permitted in a patent application, In other words, if it is the test to understand what is eligible subject matter under Indian law, then section 3 essentially acts as a filter, and therefore it is necessary to examine a patent application primarily and firstly through the lens of section 3 before you go on to test its patentability on the anvils of non-obviousness, inventive step, novelty and industrial application. Therefore, to the extent that the controller chooses to look at the application primarily on the basis of section 3K before proceeding to test it on the other criteria of patentability, in my humble opinion, this would be the better approach compared to the IPAB's approach. Even in the IPAB's decision, wherein the final decision of the controller of patents was ultimately upheld, the IPAB itself contradicts itself in two different situations. In the first introductory portion of the decision, the IPAB takes the view that novelty and obviousness must be first of all looked into before section 3K or patent eligibility is examined through the lens of section 3K. However, in the later portions of the decision, the IPAB takes a completely different view, which is consistent with the controller's approach, which is to say that so long as the controller of patents is in a position to come to the conclusion that the subject matter claimed attracts any of the provisions of section 3, there is absolutely no need to get into an inquiry on the issues of novelty, obviousness and industrial application. The sum and substance of this is this: if section 3K is meant to be the first line of defense in giving effect to public policy, in giving effect to India's take on what is patentable under the law of this particular country, then section 3 must be the first point of inquiry before other aspects are looked into. Now the point is, although this helps us understand how section 3 and the other criteria interplay with each other, both these decisions do not shed any kind of light on what is the meaning of computer programs per se. Let us proceed with an analysis of what is the meaning of per se in plain and simple English. Per se simply means as such or by itself. In other words, computer programs by themselves are not patentable in this country. If computer programs by themselves are not patentable, it gives rise to two questions. What is the meaning of computer programs by themselves, and what is the meaning of computer programs in the absence of the use of the word per se? Since we do not have judicial guidance on this aspect of the issue, we could take some kind of support or draw support from legislations or provisions in foreign patent legislations which are in pari materia to the Indian provision. The first provision that I think merits scrutiny is Article 52 of the European Patent Convention. Article 50 European Patent Convention enumerates and spells out subject matter which is patentable under the European Patent Convention. In this provision, which is Article 52, the language that is used is similar, if not identical, to Section 3K of the Patents Act, where computer programs as such are not patentable within the meaning of Article 52. There are two prominent decisions which have gone on to interpret the application of Article 52 in the context of computer programs. Both these decisions, however, take two different approaches to the same issue and come out with two different tests to understand whether or not the subject matter of a patent application attracts the prescription of Article 52(1). The first decision which is of relevance is the Vicom decision. This is the decision of the European Patent Office, wherein it went on to hold that as long as the subject matter is otherwise patentable, merely because it is performed using a modern means such as a computer, it does not render the subject matter ineligible for patent protection. In other words, if there was a lathe machine which was used to perform the function of shaping metal, and if subsequently a computer program is used to run this particular process by way of a CNC machine, then the CNC machine would not be outside the scope of patentability merely because a computer program is used to execute a function which was previously done using conventional means. The problem with this particular test is that it addresses only a certain cross section of situations where a function which was previously performed in the absence of a computer is now being performed using a computer. Therefore, it falls within the definition of computer implemented inventions. It does not take into account those instances or those situations where there is absolutely no conventional means used, and the means used is entirely a computer, and the result or the function that is being performed, or the process that is being performed, or the operation that's being undertaken is executed solely and purely by the computer. What is the law in a situation where there is absolutely no conventional means that is being used? On this particular aspect of the issue, the Vicom decision falls short of a decent explanation. Now, to address this, one could look into the second prominent decision which is of relevance to understand Article 52 of the European Patent Convention, which is the pension benefits partnership system. In this case, the European Patent Office went on to hold that the test of understanding whether or not a certain content in a patent application is patentable is to see if there is any technical character, or if there is any technical contribution, or if there is any technical effect. In other words, if the problem that is sought to be solved by the subject matter claimed in a patent application is technical in nature, and the means that is used to solve the problem is technical in nature, it then rises above the prescription of computer programs as such. Now, the proposition of this particular case could be restated as follows. So long as there is a real world application which is technical in nature, when the word technical is being used, that means it cannot be purely commercial in nature, therefore it cannot attract the prescription of a business method. As long as this happens, then the subject matter of the invention could be deemed as being patentable. This more or less seems to be the sum and substance of the case. Now the question is this: is there room for exercise of discretion by the European Patent Office within the meaning of Article 52 to look for technical character in a subject matter which otherwise seems to use a computer program to execute its operations? Now, although Article 52 does not spell out this particular requirement of technical character, the spirit of the article and the spirit of the exclusion is very clear. If something is in the realm of pure commerce, such as a business method that is meant to capture the manner in which a business is run, as opposed to a technological solution, then the subject matter clearly attracts the prohibition under Article 52. This could be one way of looking at it. Now, the second legislation that could probably help us understand the concept even clearer would be the UK legislation of 1977, the Copyright Patents Designs Act of 1977. Section 1 of this legislation is similar to Section 3 of the Indian Patents Act, and it again enumerates what is not permissible within the scope of patentability under UK law. As far as Section 1 is concerned, its language comes closer to Section 52 of Article 52 of the European Patent Convention as opposed to Section 3K of the Indian Patents Act. Be that as it may, there is still a subtle difference between Section 1 of the UK Act and Article 52 of the European Patent Convention. The subtle difference is in the language or in the phraseology. However, case laws, or the manner in which Section 1 has been interpreted by the courts of United Kingdom, have more or less ensured that the position between the European Union and the United Kingdom is not significantly different, with very minor variations. The decision that could be looked into to understand the evolution of the law of patentability of computer programs in the United Kingdom would be the Halliburton decision, wherein the Chancery Court, the United Kingdom Chancery Court, went on to identify or prescribe a test to test a patent application on the anvils of Section 1. In doing so, the Chancery Court took into account two other decisions, Aerotel and Symbian, and distilled the following test. Whenever a patent application is being examined, it falls upon the Patent Office to apply the four-step test. The first step is to construe the claims of the specification of the patent specification, to understand what exactly is being claimed by the patent, and this must be done not just on an isolated reading of the claims of the patent, but the written description or the complete specification must be read along with the patent in order to understand what is the sum and substance of the patent claims. Subsequently, the actual contribution of the patent claims or the inventive step that has been claimed in the patent claims must be identified and distilled. Upon identification of the inventive step, the next question that must be asked is whether or not the inventive step falls within the list of prohibited subject matter. If the answer is in the affirmative and the inventive step falls within the list of the prohibited subject matter, the question that must then be asked is whether or not there is a technical contribution as far as the inventive step is concerned in order for it to be pulled out from the teeth of the prescribed subject matter. In other words, prescribed subject matter plus technical contribution is patentable. Pure prescribed subject matter without technical contribution is not patentable. If one were to refine on this particular idea or on this particular precept, it could be this. If a particular idea elevates itself to the plane of application, to the plane of actual application in a technical fashion, which means if an idea can be reduced to a technological application to solve a specific problem, and since it rises above a mere abstract idea, it lends itself closer to the aspect of patentability as opposed to remaining a pure and simple abstract idea. Now, the best part about the Halliburton decision is that it squarely addresses instances where a computer program is being used in a computer to perform a purely computational function as opposed to a non-computational function. The decision goes on to observe that even if a process is entirely performed using a computer program and is executed on a computer, that by itself cannot exclude it from the scope of patentability. This, I think, is a much more relevant decision, is a much more relevant approach for the simple reason that this accommodates or permits patentability of computer programs as long as they are applied in the context of telecommunications, as long as they are applied in the context of computation. Let's take, for example, any function that is performed within a cell phone, and this was more or less the case in the Symbian decision of the United Kingdom. In the Symbian case, the classic instance that poses a huge dilemma to the to patent offices on the aspect of patentability of computer programs was tested. If there is a function that is performed in a mobile phone using a computer program, to achieve a result which does not necessarily transform the material or physically transform a particular object, would such a function or would such a process or would such an apparatus deserve the grant of the patent? The answer in this situation was squarely a yes, because it was held that computer programs, when they are used in mobile phones, are not being used in the realm of abstraction, and they are being used in a specific context, and there is a specific technical contribution that comes out during the course of its use or execution in a mobile phone. So, for instance, if a mobile phone has to establish a connection with the telecom tower or the base station, so to speak, then ultimately it is the software or the computer program within it which works on the basis of an algorithm which initiates the action, identifies the appropriate telecom tower with which a connection may be established, and ultimately establishes a connection. It must be understood that although there is a certain amount of hardware involved, at the heart of this process lies the execution of the process by a computer program. In such a situation, if it were to be concluded that this attracts the proscription of computer programs per se under section 3K of the Indian Act or section 1 of the United Kingdom Patents Act or article 52 of the European Patent Convention, then there is absolutely no scope for any innovation or grant of patents in the realm of telecommunication. This would be the consequence of a very restrictive and militantly rigid interpretation of computer programs per se or computer programs as such. Now, one can see that the position from the European Union to the United Kingdom is a position which which has broadened itself. In other words, if one were to compare the positions of the European Union and the United Kingdom, the position in the United Kingdom and its interpretation of computer programs as such is broader, pragmatic, and takes into account technological and commercial realities. The next jurisdiction that must be looked into to understand the issue as a whole would be the United States. In the United States, in stark contrast to the Indian patent legislation or the United Kingdom patent legislation or the European Patent Convention, there is no negative definition of what is permitted within the realm of patentability. In other words, there is not a single definition of what is not patentable in the United States. As opposed to these three jurisdictions, the United States permits courts to interpret Section 101 and Section 100 of the United States patents legislation to understand and to come out with propositions as to what is fundamentally patentable. And what seems to be guiding the courts of United States is whether or not there is a certain utility in a particular process and a product. Usefulness and a tangible result have been the two guiding pillars or guiding posts of evaluation of patentability of subject matter in the United States, be it in the realm of biotechnology or in the realm of business methods or in the realm of computer programs. The first decision that needs to be looked into in this in the United States is Diamond versus Deere. In Diamond versus Deere, the United States Appeal Court went on to hold that as long as a process or a product is useful and comes out with a tangible result, it must be deemed as patentable, and this decision was delivered in the context of a computer program or software. However, this is a very nebulous decision and does not lend itself to understanding whether or not a process which may be useful in a business context and which does not involve any kind of technical character would also be patentable under the United States patent law. To understand this, one could probably look into the next important decision, that would be State Street versus Signature Financial. In this case, again, the United States Federal Court went on to hold that although anything useful or anything that comes out with a concrete tangible result is patentable under the United States patent law, what is important for the subject matter to establish is a material transformation. In other words, as a consequence of use of the subject matter of the patent application, a material must undergo physical transformation, and this has been used as the test of what amounts to a technical effect or what amounts to technical contribution. This for me is a very crude way of going about it, for the simple reason that not all processes result in the transformation of material from one form to another. If one were to ask oneself if there is at all any transformation that goes on in a mobile phone as far as a material is concerned when a computer program is used to execute a certain function, the answer in 9 out of 10 cases will have to be a no. Consequently, the material transformation test does not seem to be the best way of going about it. The next decision that could be looked into to understand the position is Bilski versus Kapoor, which is a decision of the United States Supreme Court itself. Now, in stark contrast to the previous two decisions, the subject matter of this particular decision was not the use of a computer program used to execute a technical function, but the use of a computer program to execute a business method. Despite this, the United States Supreme Court went on to hold that business methods per se are not unpatentable under United States law, and if there is a computer program that executes a business method and there is a useful result, it would still fall within the realm of patentability. Now, if one were to take a step back, it becomes clearer that the position of the United States law appears to be the broadest in terms of what is permitted subject matter and what is prescribed from the scope of patentability. The problem with the decision of the United States Supreme Court is that it practically permits any subject matter which is useful to be included as part of a patent application for the purposes of grant of a patent on that subject matter. This is troublesome because it would not only increase the realm of patentability probably beyond the actual scope that was intended by the United States legislature originally when the Patents Act was introduced through the Constitution. It also ends up adding to the confusion of extreme propertization of commerce. In other words, if practically everything that is useful is capable of being protected by way of a patent, then it renders nugatory other forms of intellectual property such as copyright, and it also ends up lending or granting a strong right such as a patent right on something which is not technical in nature. Patent rights, if one were to view it through the lens of its history or its evolution or its origins, have always been granted on technological subject matter and not merely because something is useful. So tomorrow, if a university were to come out with a manner of conducting its classes which reduces the duration of the class and also ensures that students are best positioned to receive what is being imparted by way of an instruction, this would be equally useful for the university. But does it mean that this falls within the realm of patentability? Is this patentable? This is a question that ought to have been asked. In the realm of commerce, there are several aspects or several processes which could be useful, but not every process deserves or merits the grant of a patent, because patents are not meant to be granted for everything that is useful unless and until there is a technological problem that is being solved through a technological solution, through a technical effect. The most important decision which more or less clarifies the broad scope of US law is the decision of the Federal Circuit in June 2014 in the Alice case, where it was held that anything that rises above the level of a mere abstract idea is capable of being granted a patent. This for me is the broadest possible proposition of the law, which comes closest to militating the jurisprudence of patents and closest to militating the actual idea behind the introduction of patent rights. So on the basis of these three jurisdictions and the case law that has been evolved there, it could be said that the language of section 3K of the Indian Patents Act does not in any way permit the adoption of US law or the interpretation of US law on what is permitted subject matter in the realm of computer programs. We could take support from the interpretation of Article 52 of the European Union and Article 1 of the United Kingdom, and possibly apply principles that have been evolved or formulated in the United Kingdom, because the language of the United Kingdom provision comes closest to us, and the manner in which it has been interpreted also ensures that a certain balance is struck between grant of patents to subject matter involving technical contribution and rejection of subject matter which is not only just a mere abstract idea but is also in the realm of business methods. To summarize what I said, Indian Patents Act, particularly the interpretation of section 3K, has to be interpreted very restrictively for the simple reason that it is a negative definition, and negative definitions are intended to be interpreted restrictively so as to give effect to the actual policy or intent of the legislature. If, for instance, if section 3D of the Patents Act ensures that there is absolutely no room for evergreening in the realm of pharma patents, and that is the rigor with which section 3D has been interpreted by the Indian Supreme Court in the Novartis case, the same kind of rigor must be applied in the interpretation of section 3K so as to ensure that we do not end up going against the actual intention of the legislature in restricting the scope of patentability to subject matter that otherwise attracts computer programs per se. Now in this context, it becomes important to also understand the position of the Indian Patent Office in the manner in which it reviews or examines application that perhaps attracts section 3 or specifically section 3K. Reference may be had or regard may be had to the manual of patent practice and procedure of the Indian Patent Office to understand what goes on inside the patent office and what is their interpretation of section 3K, what kind of guidelines have been issued internally when it comes to review of patent applications that claim computer programs. Although it must be clarified that this manual does not have the force of law, since it is merely a manual, it is merely an internal directive from the controller to his examiners, providing them with a certain clarity or with a certain approach as to how patent applications must be examined. Nevertheless, it also tells us whether or not the first line of defense, that is the Indian Patent Office, has understood the meaning and import of section 3K to give effect to the intent of the legislature. Now, the manual of patent practice goes on to say that mere computer programs or computer programs by themselves cannot be granted patents, and there must be some kind of a system or some kind of a hardware connection or some kind of a technical connection in order for it to be granted a patent. Now, the problem with the language is this: there is a distinction between technical effect, technical contribution, and the need for a hardware, for the simple reason that ultimately, if the hardware has been available in the public domain prior to the filing of the patent application, and all that is being done in the patent application is to combine the computer program with the hardware, then even if the test of patentability were to be applied to this combination, ultimately the new feature in this combination is the computer program. In other words, the test of patentability and the tests of novelty, non-obviousness, and industrial application will have to be applied to the central feature, which is the computer program, and not to the entire system. This is because what cannot be done directly cannot be done indirectly. Therefore, if computer programs per se are not to be granted patents in this country, then the alternative cannot be to apply this particular test to the system when the system otherwise has been in public domain, when the system otherwise is not the subject matter of a patent, merely because there is nothing novel about it, and the only novel feature about it is the computer program itself. Therefore, instead of providing an escapist option, so to speak, it would help to have a much more clearer and pragmatic approach to the definition, which is to say that so long as the computer program is being used in a technical context to achieve a technical solution through a technical effect, then it would fall outside the prohibition of computer programs per se. This is perhaps the best or the most optimal way of doing justice to the language, and also to ensure that not all patent applications are rejected on grounds of section 3K, because that would mean a violation of article 27 which clearly of TRIPS, which clearly goes on to say that member states do not have the option or flexibility of discriminating between technologies. Therefore, computer programs which have a technical effect and which have a technical contribution are at par with other forms of technology or other branches of technology which merit the grant of a patent. Therefore, to summarize, in the absence of judicial guidance on what is a computer program per se, not only can the Indian Patent Office take support from the interpretation of comparative or comparable provisions in the United Kingdom and the European Union, it would also help if the Indian Patent Office were to understand the purpose of introducing the words per se with computer programs. Therefore, as long as one does not claim a patent over the manner in which multiplication is done, or addition or subtraction is done, or any of these rudimentary functions are done which are abstract in nature and which are very fundamental in nature, and there is a technical application to the computer program, it must be deemed as being eligible for the grant of a patent, or at least for examination on other aspects of patentability such as novelty, obviousness, so on and so forth. Finally, to repeat what was said earlier and to reiterate the point emphatically, section 3 is meant to be a filter to prevent grant of a patents or to prevent examination of patent applications which claim ineligible subject matter. Therefore, it would be wrong for the Indian Patent Office or the Intellectual Property Appellate Board or a court that is seized of the validity of a patent to apply the tests of novelty, obviousness, and industrial application before understanding whether or not the claimed subject matter is eligible within the meaning of section 3. One hopes that at some point in the future, courts get an opportunity to apply the interpretation or to interpret section 3K in order for the patent office to have greater clarity as to how it must deal with pending patent applications. Thank you.